would like to briefly touch on one other issue that is of great importance to me and to the people of Utah and others all over the country. Over 150 million Americans regularly consume dietary supplements as a means of improving and maintaining their health. The passage of the Dietary Supplement Health and Education Act, or DSHEA, in 1994 brought clarity, predictability, and a better understanding of what the FDA expected from industry and vice versa. DSHEA provides an appropriate structure that balances the risks and benefits to consumers with continued access and affordability. Unfortunately, my colleague from Illinois, Senator Durbin, has filed an amendment to the current bill that would undo that well-balanced approach. As the author of DSHEA, along with my dear friend and colleague, Senator Harkin, in the Senate, I strongly oppose his amendment. It would require facilities engaged in the manufacturing, processing, packing, or holding of dietary supplements to register with the FDA, provide a description with a list of all ingredients as well as a copy of the labeling for each dietary supplement product. Additionally, the facilities must also register with respect to new, reformulated, and discontinued dietary supplement products. And while I appreciate my colleague's commitment, his amendment is based on the misguided presumption that the current regulatory framework for dietary supplements is flawed and that the FDA lacks authority to regulate these products. This is simply not the case. Previous FDA commissioners, including Drs. Jane Henney, Mark McClellan, Les Crawford, and Andy von Eschenbach, as well as the former Deputy Commissioner, Dr. Josh Sharfstein, have all agreed that DSHEA provides an appropriate and sufficient level of oversight of this industry. Under DSHEA, Congress set out a legal definition of what could be marketed as a dietary supplement and safety standards that products have to meet. It allowed the FDA to develop good manufacturing practice standards and clarified what types of claims could be made. And it provided the Secretary of Health and Human Services with the authority to impose an immediate ban on any dietary supplement that poses an imminent risk to public health. DSHEA already provides the Secretary with enforcement tools of seizure, injunction, or criminal prosecution for ingredients that pose an unreasonable risk of illness or injury, are poisonous or deleterious, contain unapproved drugs or food additives, or fail to meet good manufacturing practice standards. Furthermore, under the Dietary Supplement and Non-Prescription Drug Consumer Protection Act, a manufacturer, packer, or distributor whose name appears on the label is required to report a serious adverse event related to the use of a supplement within 15 business days to HHS, submit any related medical information received within 1 year of the initial report within 15 business days, maintain records related to each report for 6 years, and permit inspection of such records. To me, that sounds like a whole lot of regulation. The FDA already has a tremendous amount of regulatory oversight and enforcement tools when it comes to dietary supplements. Yet instead of urging FDA to use its current enforcement authority to find and publish those companies that are not following the law, Senator Durbin's amendment serves to punish all responsible companies with its overreaching mandate. Should I say mandates? Finally, I would be remiss if I did not mention another obvious point. Senator Durbin's amendment would have the devastating effect of piling on more work for an underfunded agency already struggling to keep above water with its current core responsibilities. Now let me just say this. Before we passed DSHEA, there basically was no regulation over this industry. We brought together, Senator Harkin and I, the whole dietary supplement industry to get behind DSHEA. They are behind it. It took over 10 years to get the good manufacturing practices completed by FDA. More than 10 years, as a matter of fact. But we provided for them in that agreement. We provide all the tools that are necessary to supervise and regulate dietary supplements. And to now add other obligations onto this industry is just plain not right. And I hope my colleagues in the United States Senate and the House of Representatives will recognize that this is an overreach and not put up with it. We're not going to put up with it. I will be voting against Senator Durbin's amendment, and I urge all of our colleagues to do the same. And at this point, I'd like to pay tribute to my colleague, Senator Harkin from Iowa. Senator Harkin worked assiduously on this bill just along with me. We worked all the way through the Senate on a number of occasions on various things. We've improved the bill from time to time. We've gone along with the improvements. We've done everything we can to protect the American citizens. Everything that should be done, nothing further needs to be done. This is an industry that really deserves support, not condemnation. And Senator Harkin has been there every step of the way. He's a champion for the dietary supplement industry, as am I, and a lot of others in this body. I think it's time to quit trying to overregulate everything to death and cause the costs to go up by leaps and bounds. Dietary supplements are not inexpensive today, although they're a lot less expensive than they would be if we keep piling on these regulations. And frankly, we believe that we have all of the necessary language in law today to protect the American public from deleterious dietary supplements. And we've given FDA, the Food and Drug Administration, all the authority that they need. And every FDA commissioner has met with me, as I recall, since DSHEA was passed in 1994, and have said that they have enough tools to be able to supervise this industry properly and that they don't really need anything more. Make a long story short, again, this is an overreach by our colleague, who, sincere though he may be, and as important as he may be. And I would hope that he'll withdraw his amendment so that we don't have to go through this again. But if he won't, then I hope that all of our colleagues on both sides of the aisle, because this is a bipartisan effort, on both sides of the aisle will rise up and say, we've had enough of this, and let's vote these kind of amendments down. With that, I yield the floor to my